do your head when you're ready. Hi, I'm Joel Harbinson. I'm an attorney with the law firm of Harbinson, Brixey, and Corbett. We have offices in Tazewell and Statesville. And as you can tell from my white hair, I've been practicing a long time, almost 4 decades. One thing I'd like to talk about today, which is something I think a lot of people should be aware of, is their constitutional rights. We know we have certain constitutional rights. Every day we'll hear somebody say, well, you know, I have a First Amendment right to say this and have a First Amendment right to practice my religion anyway, and that's absolutely correct. And we got to bear in mind that these types of constitutional rights were things that our forefathers gave us centuries ago. And they were important to them for a particular reason. If you remember your history, we broke away from England and King George, and we became the first country in civilization to say that the government doesn't tell us what to do. We, the people, tell the government what to do. So, what I want to do today is to talk about the Fifth Amendment rights that we have in criminal cases, but particularly in driving while impaired cases. Because I've found in handling thousands of cases that people really aren't aware of the rights they have. They feel like they have to cooperate with the officer, and by cooperating with the officer over time, they essentially hang themselves. Fifth Amendment says this: you have the right not to incriminate yourself. If a person comes to see me and they've murdered somebody 2 days ago, and they say, hey, I want to pay you $50,000, I want you to represent me, I murdered this person 2 days ago. They don't know it yet, the officers don't know it, but they want to talk to me later this morning about my case. What would you advise me to do? Well, obviously, I have to advise them to invoke their Fifth Amendment right and not talk to the officer, because they would be incriminating themselves if they told them the truth. Okay, as an attorney, I was sworn to uphold the Constitution. Also, I was sworn to uphold the law. And the difference is that if that person came to see me and said, you know, I'm going to kill somebody in the next 24 hours, then if I don't do something about that, then I'm not really doing my job as a citizen or as an attorney. So we want to invoke our Fifth Amendment rights. These are things that we do not have to do, that people fought and died to protect our constitutional rights. That's what this country is all about. I'm going to do that because in driving while impaired cases, I have seen over 38 years of doing them that most people feel compelled to do whatever the officer asks them to do. And that's good, because we learned growing up in the 4th grade that the officer is our friend, okay? And they are, for the most part. But if they're investigating you for a possible criminal offense, you need to unfriend them. We need to do something that protects your rights. So I'm going to go through a normal driving while impaired stop. And before people say, oh, you're trying to tell people how to get out of DWIs. No, what I'm telling them to do is to assert their constitutional rights that this country gave them. There's a big difference in that. So, in a typical driving while impaired case, you're going to be stopped for a particular reason. You're going to be investigated by the officer, and then they're probably going to ask you to do a breathalyzer. So when a person comes to see me, there are 3 things I look at in evaluating their case. And these are hurdles that the prosecution has to go through. The first is, did they have probable cause, or PC, to stop you? And I'll not go into that in detail, but generally this: they have to have some reasonable suspicion that they can articulate that you either violated a traffic law or criminal activity is afoot. Okay? An exception is checkpoints, and there they still have to follow the law as to how to establish that checkpoint. That's one thing. The main thing that I'm going to talk about is the probable cause to arrest. That's different. That's after they've stopped you, they've talked to you, they've asked you to do all these tests, and then they form an opinion whether or not to arrest you. The third that I'll look at, of course, is the blood alcohol content test that is generally given. We generally think of it as a breathalyzer, although it's generally known as a intoximeter or intoximeter, however you want to pronounce it, depending on what part of the country you live. But those are the three things I look at. They have to jump through each hurdle to convict you. They've got to jump through this hurdle before they can get to this hurdle. And they've got to jump through this hurdle before they get to this one. So there may be cases where they didn't have probable cause to stop you, that an attorney would file a motion to dismiss based on the fact that they just didn't have sufficient reason to stop you. If that motion is granted, then your case is over. You don't have to worry about these other two. But if that's not an issue, we go to the next one, and that's probable cause to arrest. That's what I'm going to talk about mainly today, where you should invoke your Fifth Amendment rights. If they get through that hurdle, then they take you in and do a blood alcohol content test. Okay? And that's either by breath or by blood. They can take blood to do that. So, let's talk about the typical situation where you've had a couple beers, you don't feel like you're impaired, and you're driving home. Now let me tell you where that's different than if somebody is just hammered drunk. First of all, if you're hammered drunk, you're probably not going to be able to make it home without doing something significant to stop you. And a person who's hammered drunk is not, first of all, going to remember what I said in a video. Secondly, they're probably not going to do what I said to do in a video because they're hammered drunk. And thirdly, we know different kinds of drunks. Some are very nice when they're drinking. Some people are very obnoxious. And the obnoxious ones are going to be the ones who they're going to give the officer crap no matter what. Okay? This is not directed to them. They're drunk. You need to stay off the highway. Here's my best advice. Don't drink and drive. Okay? Because even if you followed my advice today, you're probably going to be arrested. What I'm saying is by asserting these rights, you may not be convicted. But again, the best advice is to not drink and drive at all. But if you do, you're going to be pulled over. And they are entitled to have two things from you. They're entitled to your driver's license. They're entitled to the car registration. So always have those readily available, because one thing they're looking at, they're observing and determining whether you're impaired or not, is how you obtain them. If you've got to search all over the place and you can't find them and you're fumbling for them, that's a common thing, fumbling through wallet for license and registration. Have them ready at all times, okay? When they come to your door, you hand them your driver's license and registration. You keep your mouth closed. You keep your mouth closed because, one, if you have an odor of alcohol, they're going to consider that in arresting you, okay? The other thing is, just keep your mouth closed so you don't say anything to incriminate yourself. Again, these are your Fifth Amendment rights to do that. Now, the best thing to do is to probably have a note already made that you hand with them and that says, I would like, if I'm under investigation, I would like to call my attorney. Okay? They're not going to let you do that. But it lets them know that you're planning to assert your Fifth Amendment rights. If they let you call your attorney, let me suggest this. Get you an attorney that you're comfortable with, that is competent, who's a friend, that you could call either at home or by cell phone, if they'll give you your cell phone, to call them in a situation like this. The officer's not going to let you, but it makes a point. After they wad it up or tear it up and put it in their pocket and laugh, they're probably going to start asking you questions. Mr. So-and-so, have you been drinking tonight? That is where you don't say anything. You can only incriminate yourself. If you truthfully say yes, that starts the meter running to them to arrest you and then ultimately try to convict you for that. You can, although you don't have to, you could have another piece of paper in your pocket or available that says, I do not intend to incriminate myself by answering questions or taking any tests, but thanks for asking. Okay? And you might want to throw that last part in because you're be nice to the officers. Do not in any way confront them. There's a big difference in not doing what they want you to do and confronting them. Don't ever confront an officer. You're going to lose that battle. So at that time, you're not saying anything. Your mouth is not open. They can't get an odor of alcohol. They might get a little if you're breathing through your nose, but that's just something that you have to deal with. But as long as your mouth is closed, for many reasons, you're fine. They're going to ask you then to get out of the car. And I would suggest that you do that, because it probably doesn't feel good to be dragged out of the car, and that's essentially what they're going to do if you don't comply. You're out of the car. Then they're going to continue asking you questions. Well, how much have you had to drink tonight? Your response, you don't have to answer that. People feel so compelled to talk to an officer at that time. That officer is not your friend at that time. That officer is trying to gather evidence to convict you of a criminal offense. Don't be combative, but don't be cooperative in the sense you're doing what they ask you to do. Well, the officer is going to get ticked. Okay? There's no way around it. You're not cooperating. They're going to get ticked. They're going to still have you to, or ask you to do then certain tests. Do you mind doing some tests for me? You don't, if you do anything, just sort of shake your head no. You don't even have to do that under our Fifth Amendment. Okay, let me tell you why those tests are not valid. Why they are only designed for failure, and you cannot do anything to convince that officer that you're not impaired by doing them. A lot of people think, man, if I can just talk to him a minute, I'll explain to him my situation, I'll do some of these tests, I'll do real well on them, and then that officer will know, man, you're not drunk, I'm going to let you go. That never happens. It never happens. And let me tell you why. There are certain tests they're actually doing. We're generally familiar with them. The first one is not so familiar to people. That's called the HGN test. That stands for horizontal gaze nystagmus, and without going into a lot of detail. That's when they'll ask you to remove your glasses, and they will have a pen, or they'll use their finger to go side to side. And the purpose, the theory behind it is that at a certain point, if you're impaired, your eyes will essentially quiver. That's the scientific basis for it. In North Carolina, 10 years ago, it was just laughed at as a reliable test. The General Assembly decided that they're going to give special status to that and make it such that it is admissible. But don't do it. That's the bottom line. You can look it up, Google it, anything you want. Don't do it. It's not a test that they are going to do to generally find something that is in your favor. They will only pinpoint in all these tests things you do wrong, not anything that you do right. Okay? The next thing that they'll have you to do is where they want you to lift your leg. Okay? So it is generally a balancing test. Stand on one leg, put your foot up, look at it, see how long you can stay on it. And they may talk to you during that time, may not. They'll let you pick a leg or whatever. The problem with that balancing test is they're going to ask you to look at your foot. Just to give an example of why it's a test that is doomed for your failure. I had an officer tell me one time in a training course that the reason they ask you to look at your foot rather than straight ahead into the horizon is that you balance better when you're looking at the horizon than rather down at a particular object. And if you think about that and you try it sometime, that's true. But they're wanting you to fail this test. They're not wanting you to give you a nice objective test for you to go, oh, I did so well on this, shouldn't you let me go? That test is doomed for failure. They'll let you keep your leg up, essentially, until you drop it. And then mark that you dropped it at a certain point. 25 seconds, 30 seconds, doesn't matter, you dropped it too soon. Again, the point is, don't do it. Okay? The next one is sort of a favorite. And these three are what they call standard field sobriety tests. They have been researched, and there is some basis, if done correctly, that can show some degree of impairment to a certain degree of accuracy, be it 60% or 70%. The National Highway Transportation Safety Administration has done these tests. So these are standard ones, and they're usually done in this order. The walk and turn is where they ask you to take 9 steps, heel to toe, on some usually imaginary line by the side of a road that has ruts and ridges from cars, and they're asking you to do 9 steps back, forward, and turn. They'll simply say turn and do 9 steps back. You are doomed for failure on this one if you take it. Again, they're only going to cite the times that you make mistakes. For instance, they may note that you missed heel to toe. Missing heel to toe, and I didn't miss that time, but missing heel to toe is if you miss it by more than half an inch. Think about that. How many people, when they walk heel to toe, are going to exactly walk normally heel to toe? But if you miss it so much as a half an inch, they're going to mark that down as you couldn't do it. Another thing is that they ask you to turn. The whole time they're looking to see if you're swaying. They're going to know if you're swaying. They're not going to put down, oh, he stayed upright perfectly. They're not ever going to mark that down. They only mark down on their report things that they can later testify in court, things to incriminate and convict you with. For instance, they may say you needed to use hands for balance. The standard for that on that test is if you're standing and if you got your arms straight down, which they tell you to do, and you go up more than 6 inches from your side, that's considered using your arms. It's not like a trapeze artist. Well, like it's 6 inches. In their minds, that's using your arms. And that's ridiculous. The last thing that they'll look at is how you made the turn. I had one case where a person who had been to military school made a complete military turn. I mean, if you can do that, you're probably not impaired. Okay? But he was marked down as doing it incorrectly as evidence of impairment because he did that rather than simply turn around like the officer told him to do. So that's how they're doing it, okay? That's how they're getting you on this. And that's why, again, it's not so much the test. I'm just telling you a little bit about the test so you don't take them. That's the only thing to remember. It's sort of like a diet, okay? To make a diet successful, you do nothing, okay? To make this successful for you is that you do nothing, okay? And sometimes that's the hardest thing to do. It's like the comedian Ron White said, I had the right to remain silent, but didn't have the ability. Okay? Probably if you're not impaired, you're going to remember this and you're going to be able to do it. That's probably the best sign of not being impaired, is that you're actually doing what I'm suggesting your constitutional rights are. Now, there are other tests that they may want you to do. Again, you're going to refuse them. You're just going to decline. Not so much refusing, it's just declining. That's a big difference. One is, everybody knows, the finger-to-nose test. You know, that's the one we see where they're going to have you lean back, close your eyes, put your head back, put your arms out, come and touch your nose. Okay? That, you know, I've had juries where I've told them, if you can all go back in the jury room and you can all do that perfectly, then find them guilty. But if you can't, find them not guilty. Now, the funny thing is, in another case, when we try these, we will have the officer demonstrate to the jury, and one reason is to show how difficult they are. But another reason is sometimes that officer will screw it up himself. I've seen an officer about fall down on a finger-to-nose test, and after the jury quit chuckling, they went out and found my guy not guilty. Because it's just obviously setting you up for failure. They're not helping you out in this situation. They're helping you get a conviction. Okay? Here's another thing, ABCs. Recite your ABCs. And usually they'll pick out, start with the letter F, and go to Z. Okay. Well, that's a test that's never been verified as being accurate, just as this test has never been verified as being accurate. But most of us learned our ABCs by singing. Okay, I don't know if I can say the ABCs without singing, particularly if I'm under some pressure by the side of a road with blue lights going like a strobe light. But anyway, you know what they would do if you said your ABCs perfectly and were singing them? They would mark down that you were singing them, which is a sign of impairment to them. So you could say them perfectly, but they're only going to pick out the things that they think are signs of impairment. That's the whole purpose of giving these tests. They want you to convict yourself. And that's what our forefathers said we're not doing in this country. If the government wants to convict you of something, let them gather their own evidence. You're not going to be put in a tower and held in chains until you admit you did something wrong. There's a Romberg test. That's a test, again, not verified, where they had you to estimate 30 seconds. And the thinking of it is that if you had alcohol or some type of central nervous system suppressant, like alcohol is, then you're going to go real slow in your counting. And it may be 40, 45 seconds that you say 30 seconds is. If you're taking a central nervous system stimulant, the theory is that you'll do that quicker. If you're on cocaine or something of that nature, you might go, now, 20 seconds. But it has no basis. Nobody in the world is ever going to hit 30 perfectly. How could you? We're not human watches. But either way you go with it, they're going to use that as some evidence against you of impairment. That's just ridiculous. So the point on all these field sobriety tests, whether they're standard or non-standard, is to don't take them. Unless you just want to make it easy for everybody. And when you're stopped, you say, "Officer, I've been drinking. I'm impaired. I'd like to plead guilty. Please, will you help me for the year that I lose my license, drive me to work and back and take my kids to soccer?" Unless you want to do something like that, you need to follow this advice, because they are trying, if they're doing this to you, they're asking you to do this, they're gathering evidence to convict you. Okay? Now, if you've done these, or whether or not you did them at all, if you take my advice, they're going to ask you to take the portable Alka-Sensor. That's the portable breathalyzer by the side of the road. And that is something that, again, is not reliable. It's not admissible in court, except to say there's a positive reading. Okay? Positive can be, and it'll give a number, 1, 2, 3, whatever, of course 0.08 being the level of impairment. But that number cannot be said in court because it's not a reliable test. So why are they asking you to take it in the first place if it's not a reliable test? The reason they want to is that if you blow anything, they go to court and say, there was a positive reading on the Alka-Sensor, which to the judge means he blew over the limit on the Alka-Sensor. Let's go on. I mean, that's another piece of evidence. Recently, I had a client who had one beer, stopped, knew enough not to do the test, and when they got to the Alka-Sensor, they saw that he wasn't cooperating. He told them, "I've had one beer. You're wasting your time." They said, "You need to take the Alka-Sensor." And he says, "I'm not taking it. I don't have to take it. I'm not taking it." And they, with 3 officers, got in his face and said, "You either take that test or you're going to jail. You're going to be arrested." Trying to put further pressure on somebody not to invoke their Fifth Amendment rights. That if you happen to invoke your Fifth Amendment rights, you're going to jail. Not because there's probable cause to arrest you, but because you're just not doing what we're saying. Again, if you want to do what they say, then just, when they stop you, just admit you're guilty and do it. Okay? So, you're probably, at this point, going to be arrested. Okay? They don't have enough to arrest you, but they will. And then you'll hire an attorney, and we will go to court, and it will be thrown out because they did not meet hoop number 2. Even if they met hoop number 1, they didn't meet hoop number 2. And because of that, the case could be thrown out, and probably more than likely would be thrown out. Simply because you invoked your Fifth Amendment rights. Now, most people don't do that. I have never had one in 38 years who declined to do everything. They might pick 1 or 2, but most do them all, thinking, "Oh, I'll show the officer I'm not impaired," or simply that they think if an officer tells them to do something, they're supposed to do it. Okay? Well, that's not your constitutional rights. I would think you'd be interested in not being convicted of something. Okay, they will take you in at that time. They will then administer a breathalyzer. You have a right to call a witness. Now, at that time, if you've taken my advice and not said a word, not opened your mouth the entire time, this is a different stage. They will, because it has consequences. These tests have no consequence for not doing them. But a breathalyzer can, because in North Carolina, whenever you're driving on the highway, with whether you have a license or not, you are giving implied consent to be given a formal scientific breathalyzer if requested to do so after you're arrested. that's where you need to call your attorney. You're going to have a right to a witness. They generally don't help. You need to have the home number or cell number of your attorney that you can call to advise you whether or not to take that test and what the consequences are. Now that's different. If that attorney tells you not to take it, you should take their advice. If they tell you to take it, and most of the time they're going to advise you to take it, regardless of what it shows, then you need to take it. Because for this reason, it could be that you blow over the legal limit. But if they can't get past this hurdle, the judge is not going to hear this evidence when you hear this motion. They're not going to know this. They're just going to hear the evidence to hear. And if it's nothing, your chances of winning that are great. The test doesn't matter. Okay? Then, what they'll do, they want one last bite at the apple. After you've had the breathalyzer, they're going to sit you down, give you your Miranda rights, right to remain silent. You know, if you remain silent the whole time, you don't need to be reminded. And if you've talked the whole time and done every test, you're not going to care about that either. Okay? Well, they're going to tell you you have the right to remain silent. Then they just want additional evidence. All it is to get additional evidence. They will ask you, were you driving? Okay? They'll ask you a series of questions. What day is it? What is the time? Hoping that you'll mess up. Again, what's their goal? Gather evidence against you. They'll ask you how much you had to drink. When did you last drink? Do you consider yourself to be impaired at this time on a scale of 1 to 10, with 1 being no, 10 being I'm hammered? And then they ask you a question, do you think you should be driving? You know, which a lot of us would think, okay, I had a drink. I probably shouldn't have been driving. And may say, no, I shouldn't have been driving. You know how they're going to use that? He admitted he didn't need to be driving. He admitted he's impaired. Okay, again, the point is, don't answer those questions. Don't answer any of the questions. They go into great detail, and that's what they do. Now, you will then probably be charged, but then it's up to an attorney who knows something about DWI law to assess your case. But again, as I tell my clients, confession may be good for the soul, but it sure as hell hurts your case. And that's all you're doing. You're giving up your Fifth Amendment rights when you do any of those tests, when you say anything, when you do anything for the sole purpose of them to try to convict you. You know, and I tell my clients after the fact this, what I'm telling you now. And they say, well, I know to do it now. But, you know, the old saying is, even God can't change the past. There's nothing I can do at that time to help that person's case. They've admitted things. They've done things. They've piled up evidence that they have hand-delivered to the state to prosecute them. Okay? That's why I think this is important. Again, these rights are your constitutional rights. You should not give them up lightly. Our forefathers thought they had a good purpose, and that was to make the government responsible for gathering the evidence to convict you, not for you to be compelled to hand it to them. You can take that advice or not. As again, a lot of people may say, oh, you're just trying to help people get out of drunk driving. Let me tell you something. If somebody, a person who's not impaired will remember what I said, number one, and will do what I said, which shows some mental ability that does not include impairment. If they're impaired, first of all, they're never going to remember what I said in this video, okay, if they're truly impaired. Secondly, like I said, they're simply going to do it. You know, they're not going to take any advice from anybody. and they're going to confront the officer. And let me say this. Most officers are very good people. They are only doing their job when they're asking you these questions. So don't give them any crap. Okay? Don't talk back to them. Like I say, don't talk to them. But certainly don't talk to them. Don't be combative with them, because they're going to win that battle. So make sure that you never confront an officer. Don't place his safety in any jeopardy, because you'll be placing your safety in jeopardy by doing that. Again, I hope you've learned something. I hope you've learned mainly that you have certain rights in addition to free speech, to right to counsel, to right to Fourth Amendment right against unreasonable searches and seizures. But this is one that it seems like in this case nobody ever invokes. And I'm not sure why. But I think it's mainly because they feel like the officer's their friend and they're compelled to cooperate with them to their own demise. So I appreciate you doing. I hope you've learned something from it. And you have certain God-given constitutional rights. Be sure to use them. Thank you.